So, ladies and gentlemen, we are now going on to study unit 4, the legal consequences of business rescue proceedings. Now, the most important consequence really is the moratorium on legal proceedings against the company. In some jurisdictions, that's all you find in their reorganization or rescue procedure, because it is really the most important part of it. It gives the company what is often referred to as a breathing space, so that they can consider their options and decide how to go forward and how they can either rescue the company or at least reorganize its debts or whatever they need to do. Okay, so that's in terms of Section 133, which states that no legal proceedings, including any enforcement action, may be commenced or continued in any forum against the company or in relation to its property or property lawfully in its possession, and note the word lawfully in its possession. However, a practitioner may give written consent, or the court may grant permission for the moratorium to be lifted and for legal proceedings to be continued or instituted against the company. There are some exceptions, but they mostly relate to criminal proceedings against the company or its directors or officers and a few others. So it's basically a moratorium on civil proceedings against the company. Now, as can be expected, there were problems interpreting this provision. So the first problem was, what do the words legal proceedings mean? What would be included in legal proceedings? And one of the first cases where this problem came up was in the 4x4 LA Sport 4x4 LA Sport 4x4 outdoor, where the court said, well, cancellation of a contract. There's a moratorium on cancellation of contracts as well. You cannot cancel a contract with the company. But when you look at the wording of the moratorium, it talks about legal proceedings. A contract cancellation of a contract is not really a legal proceeding, and definitely not in a forum. So this judgment was in fact overturned on appeal to the full bench. And then very shortly after that, or more or less at the same time, the Supreme Court of Appeal handed down its judgment in Cluta Murray versus First Rand Bank. And there the courts made it very clear that cancellation of a contract is not a legal proceeding, and therefore you can cancel a contract with a company in business rescue on the usual grounds for cancellation of a contract, in other words, a breach of contract. Then right at the beginning of paragraph 12.5, there is a discussion of the case Eravan Construction versus Becker. I don't think that case really fits in here. It is actually more to do with the consequences after a business rescue plan has been approved. So I'd rather talk about it there. Okay, so at this point now we know cancellation of a contract is possible with a company in business rescue. The next question was, what is the meaning of a forum? Would arbitration proceedings, for instance, be regarded as proceedings in a forum? And also labor disputes in the CCMA or in the labor courts. Where was that case where the Supreme Court of Appeal held that an arbitration is definitely also a forum, because you can make an arbitration award an order of court. So arbitration will fall under the meaning of a forum. Labor disputes, there was a problem because when you look at the definition of court for purposes of Chapter 6, you will see it only refers to the High Court. It doesn't refer to the Labour Court or the Labour Appeal Court. And so there were several cases where the Labour Court said, we do not have jurisdiction in matters dealing with Chapter 6. The CCMA, it falls under of the meaning of a forum, so there is a moratorium on proceedings in the CCMA as well. And then as far as labour disputes in the Labour Court is concerned, the Labour Court is not included in the definition of a court for purposes of Chapter 6. And so the Labour Court, the Labour Appeal Court, will not have jurisdiction in any matters where the company concerned is in business rescue. However, you will see that in the NUMSA versus South African Airways case, which we deal again with in paragraph 12 or part 1254, the Labour Appeal Court held differently, the Labour Court as well, where they said that they do have jurisdiction in matters where a company is in business rescue. Apparently, their view is that as long as it's not a claim for money, so that it will not affect the finances of the company, then the Labour Court will have jurisdiction, for instance, to decide whether the right procedure has been followed, whether the fair procedure has been followed, but we'll talk about that later. Then the other question was, if you look at the wording of the moratorium, you'll see it says it is against the company a property lawfully in its possession. So the question was, when is property lawfully in the company's possession? For instance, when a contract has been cancelled, can the owner of that property now demand the return of the property? Now you will see on page 304 of the textbook, the second last paragraph, it's about the third last paragraph, just after footnote 105, where it states this is not correct since the moratorium applies to all legal proceedings against the company, etc. Well, not long after this textbook was published, the Supreme Court of Appeal came out with their judgment in Timasani Pty Limited versus Afrimat Iron Ore. And there the Supreme Court of Appeal said that the three types of legal proceedings, the moratorium applies to each one of them independently. So it's not in all matters against the company. It's only when the legal proceedings are against the company as a personal right. In other words, the enforcement of a personal right. So if the company has property in its possession that is not lawfully there, then the moratorium will apply. In other words, if a contract with a company in business rescue is cancelled, the company is no longer in lawful possession, and then it is not covered by the moratorium, because the moratorium only covers property that is lawfully in the company's possession. If the contract has been cancelled, the property is no longer lawfully in the company's possession, and therefore the owner can claim it back, and it is not prevented by the moratorium because it's not subject to this moratorium. Right, then there you will also find the reference to the case where the court held that Chetty versus Nationwide Electric, or Nationwide Electrical versus Hart, where the court held that arbitration proceedings are subject to the moratorium. Now, the next problem was Section 133 states that the moratorium can be lifted with the consent of the practitioner or the leave of court. The question then was, if a person wants to institute or continue legal proceedings against the company in business rescue, must they go to court first and ask permission in a separate application? And once they have the court's consent, then they institute the proceedings, or can they do it at the same time? And in many cases, applicants did, and they had no problem. So they would ask as the first plea that they be given permission to continue or institute these legal proceedings. And then the second point would be then they ask for their actual relief. But then in the case of Elias Mechanicus, which is mentioned in your textbook at the top of page 305, there the court held that the application for leave to institute legal proceedings must be brought separately. So you must first bring this application, and then if the court gives you permission to institute these proceedings, then you can actually institute the action. You cannot do it all at the same time. Now, the irony is that in the Elias Mechanicus case, it wasn't even a claim for any money or assets. They just wanted, the applicant just wanted some information from the company in business rescue, which they refused to give. And they lost the application because they had not obtained the court's leave to institute proceedings to lift the moratorium before the time. Now, the courts are not in agreement about this. Some believe that it should be in a separate proceeding, separate application. Others say it doesn't. You'll see in your notes the BP Southern Africa case versus Intertrans Oil. There, the court held that you should you need not do it in a separate application, because the court said the question whether a court will give you permission or will agree to lift the moratorium will depend on your case, on the merits of your case. If you do not bring your main application at the same time, the court will not know what the merits of your case are. So how can the court then decide whether to give you permission to institute the proceedings or not? So it must all be done at the same time. In the Boysen versus Jonker case, which is mentioned in footnote 108, the court said, well, it will depend on the circumstances, but we must keep in mind the constitutional right of any person to access to the courts. So it was a sort of a in-between answer, not a yes or a no. However, again, in Arendse versus Van der Merwe, the court said you must make out a prima facie case, and that was really the first case where the court gave an indication of what it would look for when deciding whether to give leave to the court, an applicant or not. Okay, so that is then the whole matter of leave of the court. So at this point, we still don't know whether you must make a separate application or not. I saw a recent judgment of the KwaZulu-Natal High Court where the court said, decided that you must apply for leave to institute proceedings in a separate application. So it seems as though the courts actually prefer a separate application for leave to institute or continue your legal proceedings. And then once you obtain that leave, then you can actually institute your main action. But it's not by any means certain. That's another question that we will have to wait for the Supreme Court of Appeal to tell us what they believe to be the correct answer. Now, Section 134 deals with the protection of company assets. First of all, that the company may not sell its assets unless it's in the ordinary course of business. In other words, it's a business that sells products, or it's a bona fide transaction approved in writing by the practitioner, or as part of the implementation of an approved business rescue plan. Quite importantly, Section 134(3) states that the sale of an encumbered asset by the company is protected. And in spite of that, you still find people who believe that secured creditors, pre-commencement secured creditors are not protected. But it's very clear from this one that they are in fact protected. And that you cannot, the company cannot sell those assets unless they follow the requirements of Section 134. And basically what that comes to is that if the company wants to sell property which is subject to security, it must obtain the permission of the secured creditor, unless the proceeds of the sale will be enough to pay that creditor in full, or the company gives security for the payment of that property. But otherwise, you cannot sell property subject to a secured right of a creditor. Right, and then if it does, because it has met the requirements, the company must immediately pay over the proceeds of the sale to the secured creditor. And then you'll see in the textbook the discussion of National Union of Metal Workers of South Africa versus VR Laser Services, where the practitioners actually told the employees that of the company that when they sell the assets of the company that are subject to secured right of a creditor, then the employees will get the proceeds of that sale first, and only what's left will go to the secured creditor. And the judges actually, or the judge very harshly criticized the business rescue practitioners and called them reckless for telling the employees that they will be the first in line to be paid from the proceeds of this property subject to security, because the judge said it's very clear from Section 134 that the rights of secured pre-commencement creditors are protected. You cannot touch their security, and therefore when you sell a secured asset, the creditor holding the security must be paid first. Okay. Then property of another person in lawful possession of the company. No person may deal with it except with the written consent of the practitioner, and the practitioner may not withhold consent unreasonably. But there again, note that it's lawful possession of the company. So if the company is in unlawful possession of another person's asset, for instance, after cancellation of a contract, then they must return it to the owner. There is no way they can hold on to it. And then the property of the company in lawful possession of another person, that person can continue it, subject, however, to the right of the practitioner to suspend or apply to court for the cancellation of this contractual obligation. Because if they suspend it or cancel it, then the asset must be returned to the company. Right, then we get to post-commencement finance, which is a very important aspect, because you will see that there are several cases where the court refused to even issue a business rescue order because it wasn't clear that the company would be able to get the necessary funds for this business rescue. And you have seen in the cases of South African Airways and SA Express, South African Airways, the business rescue almost failed because they couldn't get enough money from government as post-commencement finance. And in the case of SA Express, I think some previous employees wanted to buy it. They didn't have the necessary money, and there was the government made it clear that it was not going to provide finance, and so the business rescue of SA Express failed. Now, because it is such an important aspect, because it is so important for the company to be able to obtain financing for its rescue after commencement, there is a section 135, that is dedicated to post-commencement finance and the ranking of post-commencement claims. I'm just not sure whether this section actually didn't make it more complicated than it should have been and more difficult, because it is very, very difficult to interpret and not very well drafted, but you will see for yourself. So now you would have expected in a section dealing with the ranking of claims that the first subsection would have the claim that comes first in line, and then the second one and the third one, not section 135. So it has the one that comes second in line in the first subsection. Then it has the claim that comes is third in line is in the second subsection. So it's really it's a bit chaotic. What is important that you must see that the remuneration to employees, etc., as well as claims by lenders for post-commencement finance, have preference over all unsecured claims against the company. Please note that word unsecured, because fairly early on after the commencement of the or coming into effect of the Companies Act of 2008, there were two judgments by the same judge. So the judgments are almost verbatim the same, where the judge did not read section 135 very carefully and did not notice that it was only unsecured claims that would be last in line. So this judge decided that secured pre-commencement claims would fall somewhere lower in the ranking, which is wrong. And although there have been many judgments, also by the Supreme Court of Appeal and the Constitutional Court, saying you cannot touch the secured rights of pre-commencement creditors, you still find people who believe and to give you the order of preference, and in fact pushes down the secured pre-commencement creditors fairly low down the line, which is wrong. Unsecured or secured claims dating from pre-commencement, their security is safe, they cannot be touched. You cannot use the proceeds of that asset for anything except to pay the secured claim. What is also important is that the Act states that these preferences will remain in force in a subsequent liquidation of the company. Okay, so when you look at the ranking of post-commencement claims, I have now tried to put it in the right ranking order so that it's not so difficult to make sense out of it. So first in line is the business rescue practitioner's remuneration, expenses, and other claims arising out of the costs of business rescue proceedings. Now, costs in that sense refers to the costs of the business rescue practitioner. It's not all the costs encountered in business rescue. And that was held or explained in the case of the South African Property Owners Association versus the Minister of Trade and Industry. You'll find a reference to that case. Let me see, page 316. There is also a reference to that case in footnote 192. Where once again it is stated that these costs, the contained or referred to in section 135 are the costs of the business rescue practitioner in fulfilling his duties. So in SAPOA, the organization, South African Property Owners Association, wanted the court to order that where a landlord rents out his property to a company in business rescue and the company does not pay the rent after commencement of business rescue, and for whatever reason the landlord decides not to cancel the contract, although it's obviously breach of contract, but they keep the contract going, then the property owner has to pay the rates and taxes on this property. And they wanted the court to declare that these would be regarded as the costs, as part of the costs of business rescue, because they said if the company does not have access to its premises anymore, if it doesn't have business premises anymore, then the business rescue will not succeed. The court, however, rejected that claim and made it very clear costs here are the costs of the business rescue practitioner, such as payment for consultants, travel costs, whatever else. Now, interestingly enough, there is a proposed amendment of section 135. The version that I've seen, I don't know whether that is the latest one. It was published and people could comment on it, and the wording was very bad. You couldn't really, well, you could rely on that. You could get the main message in that section, and what that proposed amendment will do is to give landlords, only landlords, a preferent right to rates and taxes they have to pay on a property that is rented by a company in business rescue and where they are not being paid their rent. So in other words, property owners will actually will get a better deal than anybody else. And the rates and taxes will be regarded as post-commencement finance. Heaven alone knows why they have to give it a label. And they will actually have a preference that will fall just under the business rescue practitioner's claims. This amendment will not also extend to people who deliver movable property or services to the company in business rescue and who have expenses that are not being paid. It's only property owners, in other words, landlords, whose property is being is rented by the company in business rescue. What the final wording will be, I don't know, but just so that you're aware of this amendment that is somewhere in the pipeline. Second in line would then be the so-called post-commencement financing of employees. Again, I don't know why they have to call it post-commencement financing, because it isn't. It isn't generally regarded as that. They could just as well have said employees have a preference right to the following claims and leave it at that. It wasn't really necessary to call it post-commencement financing. So here, section 135 provides that all claims of employees are treated equally, and these claims will have preference over all claims for other post-commencement financing, whether secured or unsecured. In other words, where where the company borrows money, makes a loan, that loan will fall under or in line after the post-commencement financing of employees. So employees will have this preference claim for all payments due to them: salary, bonuses, commission, anything else. And there's no limit to the amount. The question then is, what happens to these claims in a subsequent liquidation? Because the Insolvency Act limits pre-liquidation claims of employees. And from what I've seen so far, employees are given two claims. The one claim is the amount of money that was payable to them before commencement of business rescue, and then that would fall under the Insolvency Act, and then payments due to them after commencement of business rescue proceedings, and that will be regulated by Section 135. In other words, there's no limit, and they must be paid any salary and other payments that is owed to them. The next in line would be the real post-commencement financing. In other words, where money, capital is loaned to the company in business rescue. Here it says that they will enjoy preference in the order in which they were incurred over all unsecured claims against the company. So the Act does not differentiate between secured or unsecured post-commencement claims, whereas normally in our law, secured claims will always rank higher than unsecured claims, but here it's chronological. So in the order in which they were incurred. And then the question is, what are all post-commencement debts post-commencement financing? For instance, a supplier that delivers to the company in business rescue but isn't paid, or services that are delivered to the company in business rescue and the company doesn't pay these people for their services. Do they all have the same right? Are they all regarded as providers of post-commencement finance? And there's about a 50-50 split of opinion between people who say they do, that's also post-commencement finance, and those who say no, it's not regarded as post-commencement finance. And then last in line are all unsecured claims. In other words, where there's no security, and it is both post-commencement and pre-commencement claims. All unsecured claims fall the very last in line after all the other claims. Now, when we look at the effect of business rescue on employment contracts and employees, the employees remain employed on their existing terms and conditions, and they are referred to as preferred unsecured creditors for their remuneration that was due before commencement. The business rescue practitioner must have a meeting with employees within 10 business days after his appointment. And the employees have the right to elect a committee who will represent their interests. In other words, this committee will basically act as a liaison between the business rescue practitioner and the employees, and will protect the interests of the employees. Now, the Act says that the employee must be represented by the registered trade union if it is a member of such a trade union. As I've already said, not all trade unions need to be registered, but for purposes of Chapter 6, only registered ones are acknowledged. And what is quite well, remarkable is that employees, first of all, are protect or have rights in 3 capacities. They are employees, so just as employees, they have certain rights. They also have rights as affected person if the company owes them pre-commencement debts, and they are just as employees, they have certain rights. So they are protected as creditors for claims that they have had before the business rescue commenced. They are as employees, they have certain rights, and as affected persons, they have certain rights, because employees, whether they have a claim against the company or not, employees are affected persons. So they have 3 well, what shall I call it? 3 groups in which they fall and where they have certain rights. When we get to other contracts, the effect of business rescue on contracts that are still running, Section 136(2) provides that the practitioner may suspend contractual obligations arising from contracts into which the company entered before commencement of business rescue, then the practitioner may suspend those contractual obligations. That's really, I think, to stall or prevent the company from going into or having to comply with contractual obligations that may undermine the rescue procedure. So the practitioner can decide one-sidedly to suspend these contractual obligations, but these obligations must stem from pre-commencement contracts. In other words, contracts entered into by the company before the commencement of business rescue. However, employment contracts and financial market contracts may not be suspended. They are immune to that. So employment contracts must continue as they were before commencement of business rescue. The business rescue practitioner may also apply to court to cancel a contractual obligation on terms that are just and reasonable. I haven't seen any cases so far where a business rescue practitioner has applied for the cancellation of a contractual obligation. I don't think that's really necessary. It will hardly ever be necessary. So it's really the suspension of obligations by the practitioner that are the most important. The other, once a provision in a contract has been suspended, the other contracting party may only gather third party, what do they call it, damages, but may not demand specific performance. So the other party cannot insist on the company complying with its obligations. However, that sounds like a very strong protection of employees, because it means if the company entered into a contract with very onerous obligations, the business rescue practitioner can suspend that obligation and until the company is in a better situation. However, you will see that there is a discussion in your textbook, I think so. Let me just see. No, I don't know if it's in your textbook. Oh, yes, it is. Under other contracts and yeah, okay. In paragraph 1255, there is a discussion of BP Southern Africa versus Intertrans, where the court said, well, we now know that it is possible to cancel a contract with a company in business rescue if that company is in breach of contract. But if the company does not meet its obligations under the contract after the business rescue practitioner has suspended the obligation, that cannot be regarded as a breach of contract because it's not unlawful. It is a statutory right that has been given to the practitioner to suspend an obligation. But in BP Southern Africa versus Intertrans, the court held that if a company's obligation, a company in business rescue, has reciprocal obligations, in other words, the company has an obligation and then receives something in return, so that it's a reciprocal, then if the company suspends or stops complying with its obligation, the other party to the contract can do the same. So if the company doesn't perform under the contract, the other party doesn't have to do so either, because it's reciprocal. These two are tied together. The one is in exchange for the other, and in that case, the other party will also have the right to cancel the contract. So that won't help the business rescue practitioner an awful lot, because if they suspend these obligations, the other party can say, well, it's reciprocal, and I am now regarding this as a basis for cancellation of the contract, because if you don't perform, then I don't have to do so either. So if you are not paying rent for my property, then I don't have to make this property available to you, and so I can cancel the contract, and I can tell you that I want to, you have to vacate the premises, and I am going to take over my property again. We haven't had a Supreme Court of Appeal decision on that yet, so I'm not sure whether they will do that as well, whether that's what they will decide, but it does look as though that is the correct position. As far as shareholders are concerned, there's generally no change in their rights. They have very limited participation rights, and they can only vote on the rescue plan if their rights are affected. So that is not very often the case, and so they play a very small role. When you get to the directors, they continue to hold office, but they are now subject to the authority and instructions of the business rescue practitioner. So they cannot act on their own. They can do the ordinary day-to-day things, but serious and important decisions must be taken by the business rescue practitioner, or at least with his or her consent. The directors must also cooperate with the business rescue practitioner, and in return for that, they are excused from most of their duties in terms of Section 76 and 77, while they are acting under the instructions of the practitioner. So then they cannot be held liable for breach of their properties. Then a fairly strange provision, which is that the directors may be removed from office only under very specific circumstances. If they fail to cooperate with the practitioner or they hinder the practitioner, but the practitioner cannot decide to remove an officer of the court from his position. The practitioner must obtain a court order for that. Okay. And as you can see, the directors can only be removed by order of court and on very specific grounds, not for just any ground. So it's quite difficult for a business rescue practitioner to get rid of directors if they are maybe sabotaging the business rescue, unless they are prepared to go to court and they can base their application on one of the very specific grounds mentioned in the Act. When we get to creditors, they of course are the most important of all affected persons, in the sense that they have the rights to be notified and to participate in stages of a proceeding. They can also form a creditors committee, and they must always vote on the business rescue plan. In other words, creditors always have a vote on the plan, not just sometimes. And their voting interest is equal to the value of the creditor's claim against the company. And the interesting thing is whether it's secured or unsecured, it doesn't matter. The creditor's claim is based on the full value of the debt. In insolvency law, for instance, a secured creditor can only have a vote based on the unsecured part of his or her claim. You don't have a claim on the full amount, but in the case of business rescue, we have a very specific exception to that, and that is where the claim is secured. Right, that brings us to the end of study unit 4. Now we are going to deal with study unit 5, which is all about the business rescue practitioner. The qualifications for appointment and the appointment itself. Let me just, I think I'm going to stop the recording here for a moment and then take us a break.